Welcome to Estate Planning Beyond the Binder.
Welcome back to Estate Planning Beyond the Binder with Brian Chu, managing partner at OC Wills and Trust Attorneys and a leading estate planning attorney serving Orange County families for over 25 years. I'm Lisa Mosby, your host, and today we're talking about do-it-yourself estate planning and why this can prove to be a nightmare for Californians. Welcome, Brian. Thanks for being with me.
Hi, Lisa. Thank you for having me on.
With so many people using generative AI to draft personalized wills in 2026, what are the biggest mistakes that you see people make when trying to do it yourself when they're estate planning?
I mean, ultimately, when you do these documents, if you're, using a AI or, even other software to generate a trust or a will or an estate plan, the issue is it's doing it at your direction. All right. You're not getting any kind of legal advice. They can ask you some basic questions and generate a document, but they're not asking a lot of the important questions that come up that can only be asked by somebody like an attorney, and having those issues addressed as part of the estate plan. As I always tell my clients, my job, when I meet with my clients, is to understand your goals and concerns and give you options. Okay. And generally AI, they can't really do it that well because it's limited as far as what it can ask. And a lot of the questions aren't just legal questions. As I tell my clients, a lot of it's practical issues, family political issues, family dynamics. And those are things that, AI or any other software really cannot anticipate, cannot address. And that's usually the biggest issue, is that, when you do it yourself, you don't know what you don't know. And sometimes, I always tell people my job is to understand your goals and concerns, and sometimes give you goals and concerns you didn't have or had never thought about. And then that's what comes from my experience as an estate planning attorney, is to present those things to you. At the end of the day, my job is not to tell you what to do. My job is to give you options, and then you decide what's important to you, because I don't know. But again, that's the biggest issue with the software or AI.
You took the words right out of my mouth when you said, we don't know what we don't know. Most of these DIY platforms provide a generic template that claims to be state specific. How often do you find that these forms fail to meet the actual execution requirements, like specific witness counts or notary wording, those items that might be required by each state's law?
Usually the issue is not so much the language in the documents, but yes, some of the formalities, may or may not be accurate, especially with AI. And we know AI, it learns things, and it may learn it incorrectly. And so while there is obviously some potential that the document is just, factually wrong, like I said, the biggest issue is the docket meeting the formalities that are required for that particular jurisdiction.
Brian, I've heard that people use online software to create a living trust, but fail to fund it by retitling their assets. Why does this mistake render the entire DIY project a waste of time and money?
Well, I mean, so the biggest issue is, our focus, and that's why we call this podcast Estate Planning Beyond the Binder, is that the documents themselves are not enough, okay, to have an effective estate plan. I mean, our goal when we meet with our clients is not just get them a binder of documents, but make sure that plan is effective. And the biggest part, especially when you have something like a revocable living trust, is in order for that plan to be effective, to avoid things like probate, we need to have, my clients need to fund their trust. Now, we typically take care of some of it for them, but then they are expected to take care of some of themselves. But that's our job, is to give them instructions, provide them support. Because at the end of the day, if they don't fund their trust, funding the trust is making the trust the owner or beneficiary of an asset. That asset, if they pass away, if it's just in their names, could end up going to probate. And so obviously that's the primary goal for most of our clients in having a revocable trust, is to avoid the cost and expense and time of probate. In order to avoid that, you have to have the trust funded. And, for the most part, while they might tell you a few things when you do it yourself, they're not ultimately A, doing the work for you, or B, following up with you and checking in with you, obviously, to make sure that the work is being done. As far as the funding, because that's something you cannot fund. The trust cannot fund itself. Okay, there's nothing you're going to do as part of the process of creating the document that's going to fund the trust, typically with the key assets like a house or a bank account, without you doing another document that gets filed with the institution that controls the titling of that asset, like the the local county recorder for the property, or your bank, or your life insurance company, or your 401k company. There's paperwork that has to be done with them in order to affiliate that account with your trust. If you fail to do so, then it's that account is unfunded and thus potentially subject to probate.
DIYers often use everyday language like, I want my kids to share everything equally. Why can that simple sentence lead to a court battle if one child has a disability or one child provided 10 years of live in care?
That language, can be effective and, obviously is fairly common. Hopefully, for most of us, we're treating our kids equally. With that being said, there are a number of circumstances why you may not want that to occur. And you want to make sure your estate plan reflects that. As I always tell people, it's your money. You should decide how you want it to be split up. And if you want it to be split up equally, great. But, there's a couple issues there. When we draft a trust, while we might say things are going to be divided equally, we also address the fact that, your share, if, one of your children, God forbid, were to predecease you and they have their own kids, that their share would go to their children, for example. And the statement that, all my children would be treated equally, that may not happen where, if you have 3 kids and one passes away, their share will just go to the other 2 kids instead of potentially to their children, which is what maybe your intention was. But ultimately, he said, you want, that's where we address issues with our clients is there a reason why not to treat the kids equally beyond just, family politics of, getting along or not getting along, or, maybe even again, who's taking care of you. But, disability, especially, we have a lot of clients who have, children with considered special needs. And we do need to address that specifically in the trust in a different way, whether it be they get more money because, a lot of times the person who's disabled is not going to be able to earn a living. And so maybe we need to give them more than an equal share. And then on top of that, we address this in other issues is, you don't want, if they're qualified for certain government benefits such as SSI or Medicare or Medicaid in their state, which is a, asset needs-based government benefit, we need to make accommodations for that so that whatever they might inherit from you one day would not disqualify them from the benefits. So again, simple statements like that, again, well, that may work for a lot of people. There's plenty of circumstances where that won't work out as well as you'd want it to, or at least not achieve your intent. And that's our job is, again, understand what is your intent, what are your concerns, and draft language that addresses those issues.
How do DIY plans typically fail to give executors the legal authority they need to access and report on crypto or online business accounts?
I mean, the documents themselves are probably less the issue when it comes to something like that. It's the fact that, as we talk about funding the trust, part of funding the trust and making the trust effective is also the logistical aspects of it. And I talk about that with my clients. Again, this is not a legal issue so much as is making sure that somebody can access the account. Okay, especially when you have crypto. There is no, with most crypto accounts, there is no way you could, unlike a regular bank account, checking, savings, life insurance, where you could name a beneficiary, in which case, if you have a trust, you name the trust as the beneficiary of that account. Okay, and that's what's funding the trust. Crypto, as an example, you can't do that. You cannot name the trust as even if you have it at, some of these Coinbase and Robinhood and things like that, you cannot name a beneficiary for the crypto part of that account. And so again, that's something that the AI and do-yourself isn't great at explaining. How does your executor / trustee gain access to that? Same thing with some purely online banks. Some of these newer banks don't allow beneficiaries or don't allow a trustee to be a beneficiary. And so what happens then? How does that trustee gain access to it? So it's not so much the documents itself, it's the fact that they're not getting advice on how to deal with that situation. And again, some of it's legal, some of it's practical. The practical side is, well, you need to make sure that whoever it is can get access to it. Now, technically, that's not a legal issue because yes, they have the right to access it according to the document, but can they actually get to it? And that's, you need both. You need the right to do it and you need to be able to get to it. And, that's what we talk about with our clients is, well, how does that work? What is the security protocol? Because whatever, as with all the hacking and stuff like that, the security protocols to get access to something, especially like crypto, is significant, especially if it's, online or it's a physical drive or something like that. How does that work? A lot of the people who would be involved with our documents, if something happened to us, would have no idea what to do. And so again, that's not a legal issue. It's practical. How you got to make sure that, you educate them and that you have a security protocol in place as far as how they would access those assets. But at the same time, there's no, if you give them access, there's no fail safe in the sense of A, they lose the access, or B, they abuse that access. So, those are things we have to talk about. And that's a discussion I have with my clients to make sure that, that's done the best we can.
Let's talk about the cost of cleanup. Clients often DIY to save a few $1,000s here or there. In your experience, what is the average cost to for a family to fix a broken DIY probate court situation after the person has already passed away?
Well, that's the biggest issue is, if, once the person's passed away, it's too late. You can't, they said it's not really a matter of fixing, it's just dealing with the consequences. And the biggest consequence is, one of two things. A, the trust, like you mentioned before, wasn't funded. And we can see that with, attorney created documents where the firm isn't following up with their clients, let alone, do it yourself. And now, no one, the trust and estate plan's out of sight, out of mind. And nobody's remembering, hey, I need to fund this trust. And they buy another house, they don't put it in the trust. No one's reminding them to do so. And then something happens to them, and now the house goes to probate, and now we're looking at tens of thousands of dollars of legal fees, especially here in California. That's going to be paid for no good reason, and it's going to tie up the money for 1 to 2 years. That's what probate is. And again, it's easily tens of thousands of dollars. The other issue, obviously, is, was the trust effective in terms of doing what you wanted to do? And, obviously, that's what you're hiring an attorney to do, is to make sure the trust and your estate plan does what you want it to do. With the do-it-yourself, you're counting on software doing what you want to do, and with nobody, no legal person, no attorney reviewing the document to make sure the trust is accomplishing what you want to accomplish. Especially, again, it's not so much, like I said, treating everybody equally is one thing, but it's just addressing all those other issues that exist currently that you need to address, and are they being properly addressed? As example, we might want to give money to our parents, okay, to support them. But we don't want that, and while we could give that money to our parents, we wouldn't want them, if we give the money to them and then they don't need it, we may not want that money to go to our siblings, because that's what happened. If we give it to them, then our parents' estate plan takes over, which probably says it goes equally to myself and my siblings. And again, that's okay. But if my intent, I really want that money to go to my kids, if it's not being used for my parents, I would need to make sure the trust addresses that specifically and in a way that the money doesn't necessarily leave the trust. And so, again, those are things that, those are common circumstances where do-it-yourself is not going to be able to address those type of issues.
We keep circling back to, we don't know what we don't know. If we don't do this on a day-to-day basis, we don't know the questions to ask. We don't know the avenues to go down. This is a 3-part question for you. I'm thinking, do DIY forms account for complexities of second marriages or stepchildren? How do these forms accidentally disinherit biological children or leave a surviving spouse in a legal lurch?
These documents aren't really set up to deal with those issues, or at least it's not even so much they're not set up. They aren't set up to even address those issues, in the sense of those are not questions they ask you about. Okay, are you trying to take care of a stepchild or not? Is adopted. If you adopted somebody, if you have adopted grandchildren, how are they treated? All of these, and then obviously the family dynamics of a second marriage with, kids from prior relationships and things like that. It's very difficult for the do-it-yourself programs or AI to address those issues in the documents. Or again, it's not, they just don't ask the question. How do you want to deal with that? Is this an issue? Or even, for married couples, even if it's not a second, marriage, if something happens to one of them, what happens? Does the survivor get everything, or are we going to do something else? And those are questions that, do-it-yourself and AI cannot really ask you in an effective way. And then more importantly, present you the options. And then what I do is, once you make your choice, I make sure you understand the consequences. Okay. What are the consequences of not treating your kids equally? What are the consequences of having a surviving spouse get everything? What are the consequences of, a new spouse getting all the money and such, or what are the consequences of not giving your new spouse all the money? You know, will they have enough money to survive on it? Or in your first marriage, does the surviving spouse have enough money to live on? I don't know the answer. AI is not going to know the answer to that question. And they're not even going to ask that question. And those are the practical things when we're trying to design the estate plan that, we ask our clients, these questions. And again, we don't know the answer. Only they know the answer. And then even then it's a judgment call. It's, making the best judgment. And again, AI and do it yourself is just not really set up to address any kind of judgment issues. You tell it, I want to split equally. Sure, it can do that. But, or unequally, it can do that as well. But what are the consequences of doing so? And again, it's not a legal consequence necessarily. It's a political consequence. And, that for me is a lot of times more important than some of the legal consequences. If things went to probate, okay, fine. That's going to cost everybody some money. And, that is what it is. But, is it going to cause a rift in the family? And sometimes that's the structure of the trust. We, sometimes we'll put, one sibling in charge over the others, and that's fine, especially if everything's being divided up equally. But, one of the older siblings has to oversee the money on behalf of another sibling for some period of time and potentially say, no, you can't have this money for that reason. Could that cause a rift? Again, I don't know. Maybe it would or maybe it wouldn't. And is it worth it? And so those are the questions that we ask our clients. Is it worth it to do this at the risk of potentially causing a rift in your family? And is that more important than the money? Maybe it is, maybe it isn't. I don't know. But again, that's something AI and do yourself cannot address.
Brian, I think you've opened our eyes to the need of having conversation with an attorney who can steer us in the right direction. So I think we'll leave it there for today. Folks, your estate plan is only as strong as the people you trust to carry it out. If you're not sure who to name, or you just want to make sure that your choices are still a good fit, Brian and his team can walk you through your options and help you make the right call. Visit ocwillsandtrusts.com to learn more or schedule a time to talk through your situation. Also, be sure to like, subscribe, and leave a review if you enjoyed today's episode. Thank you.
Thank you so much for having me on.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.